Okay, we got one more substantive video because the rule of negligence is really important. While it's true cattle trespass was historically a strict liability tort, it was the owner of the cattle that would be legally liable for any damages caused by the cattle. And by the way, that's the general rule also for wild animals. So if you're Joe Exotic and you run or Carol Baskin and you have a animal sanctuary or a exotic animal park, and any of your wild animals injures your employees or, God forbid, a member of the public, that's going to be strict liability. But there's another major rule the common law has adopted for situations that don't involve wild animals. In the case of cattle, we saw, for example, in Florida and many other states, the rule has also been changed by legislation. But what is negligence? Negligence is the kind of rule you normally use, for example, in a car accident case or a case involving injuries that don't involve wild animals, generally speaking, or that don't involve what the law would refer to as inherently dangerous or inherently risky activities. So negligence actually today is the dominant rule that courts use in deciding whether they're going to impose legal liability on a business or on any other defendant for injuries that may have occurred on the premises of the business or to any of the customers or employees of the business. So negligence, I can't again emphasize enough, like contracts and property rights, a huge area of the common law that on a daily basis affects business firms and their operations. So negligence is this. First of all, for a plaintiff to win a tort lawsuit under a negligence theory, the plaintiff's going to have to do a lot more work. It's not a bright line rule, it's a standard. And that standard has 4 elements. First, the plaintiff has to show that the defendant owed him or her a duty. Now, there are different ways of establishing a duty. Generally speaking, when you have a business firm and your firm is open to the public, you have premises that are open to the public, the courts are going to presume that you have the highest duty of care that you owe to your customers and your invitees, the people that are on your premises. Is there a duty? Generally, there's going to be a duty. Some courts have even gone as far as to say, look, everybody owes everybody else this general duty of care, to use ordinary, reasonable care under the circumstances. It's a very contextual, as you can see, test as a standard. Okay? But that's only one element, establishing the existence of a legal duty, which generally there will be. 2 is negligence. Did the defendant, the party being sued, did he or she comply with her duty, right? Did he or she act in a way that actually fulfilled the duty, or did their conduct fall well short of their duty of care? So here, and this is a real judgment call. This is why we have juries, right? Something a jury would probably have to decide. Sometimes we're not going to go into all the specifics. There are doctrines of negligence per se and res ipsa, Lockwood, or common law doctrines to allow a court to assume that the duty has not been complied with. But generally speaking, it has to be proven with facts in the case. So you have to have a duty, and the defendant or the person being sued, his or her behavior has to fall below the duty. Next, there has to be an injury. So the plaintiff, and this is a really, it sounds obvious, but it's not. Think about a lot of privacy cases, right? Somebody takes one of your pictures and posts your picture without your consent, right? You may want to consider that an invasion of privacy. And in fact, there's a tort known as the invasion of privacy tort. But the problem is that having your privacy invaded, most courts have said, by itself is not going to be a sufficient injury. You're going to actually have to also show some kind of psychological harm, physical harm, or other type of economic loss that posting that picture caused to you. So it's really hard. You have to prove an economic injury. And lastly, the common law requires, it's called the causation proximate cause requirement. Oftentimes, lawyers also talk about but-for causation. For this course, we don't need to go into those technical details. I just want you to know the big picture, that in order to establish that a defendant, in order to establish that somebody acted negligently, you're going to have to show that they had a duty to you to act with care towards you, that they in fact breached that duty, that they acted in a way that was below the standard of care. And the standard of care is what would a reasonable person have done under those circumstances. 3, you have to show that above and beyond the breach of the duty, you have some physical or economic or even emotional injury. And so you may need experts, you may need doctors, you may need receipts, invoices, whatever you can muster to prove your injury, your economic, physical, emotional loss. And lastly, you have to have this causation. You have to show that it was the defendant's specific behavior, not some other external factor that was sort of the predominant cause. And that also has generated a lot of case law. The basic idea with negligence that I want to get across is that suing under a negligence theory is a lot harder than suing under a strict liability theory. Strict liability, all you have to prove, for example, in the case of cattle trespass, all you have to prove is that who is the owner of the cattle, right? And that's it. If the cattle is, damaged your crops, we're going to impose automatic or strict. That's why it's called strict liability. With negligence, right? And according to the Rocco v. Hendry case, Florida switched over to this more contextual rule for cattle trespass. With negligence, you have to show, okay, did your neighbor owe you a duty? Did they, comply with that duty? What kind of fence did they put up there, Maybe they did comply with the duty, and even though your crops got injured, they would have got injured anyways, So it's a lot harder to win. Maybe there's no proximate cause. Maybe somebody scared not your neighbor, but somebody else, a teenager committing a prank, scared the cattle, and that's what led them to on your property. So with negligence, that's why it really matters what theory the plaintiff is suing under, because strict liability is, generally speaking, a pro-plaintiff, very favorable legal standard for the plaintiff, whereas negligence, right, gives the defendant a fighting chance to fight back, because there's going to be an asymmetry. Same is true with contracts. With contracts, you recall, the plaintiff has to prove the 4 elements of a contract in order to enforce a promise in a court of law. All the defendant has to do is refute any one of those elements, whether we're talking about negligence or contract. If I refute any one of those negligence or I assert another type of defense, then I can get off scot-free or try to minimize my damages. Okay, we've talked about a lot. Believe me, we've only scratched the surface, but I understand it's a survey course. What I want to do is one last wrap-up video, and just to tie all these loose ends together. Thank you for bearing with me. Thank you for your patience. I'll see you on the other side.